Hi everyone. In this video, we're going to be talking about the very basic concepts of arbitration and generally in terms of ADR. Let's dive right into the conversation with Dr. Nain with a question. Dr. Nain, would you like to explain to our audience what is ADR in general, and specifically if you could throw a little bit of light on what arbitration is?
Okay. ADR, the full form is Alternative Dispute Resolution. It's an alternate to the court system. The court system is understood as a normal methodology of the place where you go in case of a dispute of any nature.
Correct.
ADR, which comprises of mediation, conciliation, arbitration, out of the court system, are done in a methodology where all the factors can be under the control of the parties themselves. So the outcomes can be faster, more productive, and in control of the parties themselves rather than the judge in the court.
Fair enough. So is this attempt to build a system of dispute resolution other than the court something that is new, or it has existed? Could you throw light on a little bit of the historical aspect of this piece?
Not one in place of the other. The informal methods of dispute resolution had been prevalent in India since time immemorial. Our old panchayat system is an absolute prime example of alternative methods of distribution. The system needs to be strengthened. The method needs to be strengthened. There is more awareness which is needed for arbitration, mediation, and conciliation rather than only going to court. The cost of delay in justice is tremendous, not only because of the logjam in our judicial system, but it impacts the cost of business, the working capital of business. So it's all the more reason that we focus on ADR, particularly mediation, conciliation, arbitration.
So, Dr. Nain, if you could just explain to our audience, primarily we are a country which relies very heavily on litigation as a form of dispute resolution, where there is a judge, there are parties which are represented by lawyers in a court of law. How does arbitration provide a different setup for dispute resolution?
See, the court, using colloquial language, is a my-bap sitting there in the form of a judge. In arbitration, the two parties can decide A, who will be the arbitrator between themselves, B, what are the procedures to be adopted, C, it could be the powers to be given to the arbitrator, D, it could be the fees to be paid to the arbitrator, E, it could be the time in which they want the arbitral award, and next is the rules of procedure, which is not possible in a court of law. But all this is feasible provided the parties have an arbitration clause or an arbitration contract in the beginning. Once a dispute occurs, it's difficult for two parties to agree on anything.